Hello, welcome back. You've been through the ups and downs, twists and turns of getting ready to sue the credit bureaus. We've gotten out of arbitration clauses. We've gotten our credit reports from the official source. We've been through with a fine-tooth comb. We've sent dispute letters and we've got dispute results. Now we're ready for the next step. And this isn't just a box to check. This isn't just a formality. This is putting the credit reporting bureaus to the test. In this step, we're applying for credit. Hey folks, this is Consumer Protection Attorney Bill Clanton. I've helped thousands of consumers deal with credit reporting inaccuracies, debt collection harassment, bad background checks, and all sorts of other consumer-related matters. Thanks for watching this video, and let's get into it. After the hard work of getting your credit reports and disputing errors on them, you might think the battle is over, but it's not. We have to make sure that if there are any corrections, that they have been taken care of, and if the information's not been corrected, that these errors are significant enough to affect your ability to get credit, whether it's a higher interest rate or being turned down for credit. So how do we use this as evidence? Well, you need to keep track of everything you do, every credit application you fill out. You need to keep a copy of it, whether it's a picture on your phone or whether it's an actual paper copy. You need to have that. You need to have every credit denial letter that you get, and to save each one of those. Each one of these is like a brick in your case and assembling your case. Adverse action letters are the best evidence you can have of credit denial. They tell you why you were denied, which bureau denied you, the reasons they denied you, and these should line up with the errors in your credit report. So applying for credit is the next step, and it's an important step that will help make your case. When errors turn into credit rejections, it's not just a denial of credit. It's an impact on your life. It's an effect on your reputation, and you must document this impact. Having a credit reporting error just be on your credit report is been considered by the courts by having a letter written but never sent. You have to be able to show that the inaccurate information was sent out, and then that inaccurate information caused you some harm. Being turned down for credit is the harm. And so applying for credit proves to third parties, courts and jurors, that the credit reporting errors were significant enough to cause you actual damages in the form of being turned down for credit, in the form of not getting the car that you should have gotten, or not applying for, not being approved for the mortgage that you applied for, or not even being applied for a small line of credit or a piece of jewelry. It's important that you document each credit application and save each and every adverse action letter. These will become your testimony, your evidence in your case. Now let's talk the law. Courts across the country, from Texas to Wisconsin, from California to New York and Florida, have said that you have to have actual damages to bring a case, not just hypothetical damages. The United States Supreme Court, in the Ramirez versus TransUnion case, said that when TransUnion did not publish people's information, false information, that those people didn't have a case against TransUnion. And TransUnion was saying that people were on the OFAC list, the terrorist watch list. And even though TransUnion did not publish that some 6,000 people were on the terrorist watch list, those 6,000 people couldn't sue. Only the 1,000 or 1,500 or so that had actually the false information published to a third party could sue TransUnion. It's very important that you can prove that your negative information was published to a third party. In most people's cases, that's a credit grantor, a credit card company, a store, a merchant, a mortgage lender. Sometimes it's a background check, a job check, a tenant background check. Those are also forms of credit reports. Anytime any false information on a credit report causes you to be turned down for anything, whether it's credit or a new apartment, a new home, then you should receive an adverse action letter. And that letter is what we can show to the courts and to opposing parties to show that their credit bureau's mistakes cost you an opportunity, that you have actually lost something because of an error on your credit file. It's no longer an unpublished error, a written letter that was never sent off. It is now defamatory, negative information out there in the hands of third parties that has caused them to turn you down for an opportunity. That is what gives rise to a cause of action under the Fair Credit Reporting Act. You have false information on your credit report. You disputed it. The dispute did not resolve it. And because of that information that was unresolved by the dispute, you've been turned down for credit. Now, you've met the 4 things you need for a Fair Credit Reporting Act case. With this legal background, you can now see how applying for credit is not just checking the box. It's now a chess move. It's putting the pieces in place so that you can bring the best case possible against the credit bureaus. It's advocating for yourself. It's putting the bureaus to the test and their dispute resolution to the test. If they say they resolved it, if they verified it as accurate, well, let's go test that verification in the market, right? Let's test their dispute resolution in the free market of credit. That's what you're doing when you apply for credit. And you're building your case. You're developing a case against the credit bureaus to show that their dispute resolution is inadequate, that they are not working for consumers, that they're not helping you out. Remember, each application for credit is an act of self-advocacy. It puts you in the driver's seat. It puts you in control of your credit. So when you apply for credit, do it with the precision of a technician, the tenacity of a consumer, and be on the lookout for those adverse action letters. Thanks for watching this video. If you have any questions, put them in the comments below. Feel free to reach out to us. If you get stuck, if you need more help, we're here for you. Thanks for watching.